Picture this. April 16th, 2025. You walk into a courtroom in Delhi, absolutely packed. The air is just crackling with anticipation. You've got top lawyers, political heavyweights, religious leaders, all eyes forward.
Right, all focused on those three judges.
Exactly. And they're all there for one reason: the fate of the Waqf Amendment Act of 2025. That's what we're diving into today.
And it's fascinating just seeing who's in that room, isn't it? The lawyers, the politicians, the religious figures. It really shows how many different groups have a stake in this.
It absolutely does.
Yeah.
Now, for anyone maybe not fully up to speed, what exactly is a waqf?
Well, fundamentally, it's an endowment under Islamic law. Property, assets, set aside for a purpose.
Like religious or charitable purposes?
Precisely. Think mosques, community schools, orphanages, things like that. They're meant to be held in a kind of sacred trust for the community good. And they're managed by waqf boards.
Okay. And there's been a law governing this since, what, 1995?
Yes, the original act was 1995. But this 2025 amendment, that's what's really causing all the debate.
Right. Because these waqf properties, they often represent, well, significant community resources, don't they?
They really do. They're integral to the social and cultural life for many Muslims. It's not just about the buildings. It's about a tradition of charity, of community support. So any change is going to get a lot of attention.
And this particular change, this 2025 Act, it didn't just sail through Parliament. I mean, the votes were quite close, weren't they?
They were surprisingly close, actually, when President Murmu signed it on April 5th, 2025. Let's see, it was 288 for, 232 against in the Lok Sabha. 128 for, 95 against. So, yeah, not exactly a landslide. It tells you right away there was significant opposition.
That close vote really foreshadowed the legal challenges, didn't it?
Absolutely. It signaled a deep disagreement right from the start, which is why we're seeing this big showdown now in the Supreme Court.
So what's the core disagreement here? What's the government saying versus the critics?
Well, the government's line is essentially about reform. They argue the changes are needed for better oversight, more efficiency, transparency.
Cleaning up management, basically.
Yeah.
Dealing with disputes.
Right. Curbing potential corruption, making things run smoother. They frame it as being in the public interest, good governance.
But the petitioners, the ones challenging the act,
they see it very differently. For them, it's an overreach. Some are calling it a power grab by the state.
A power grab that infringes on religious freedom.
That's the core concern, yes. Infringing on religious freedom and the Muslim community's right to manage its own institutions, it raises that fundamental question.
About the state's role in religious affairs.
Exactly. How do you balance accountability with religious autonomy? That's the tightrope the Supreme Court has to walk.
Which brings us right back to that courtroom on April 16th. This feels like more than just a legal case. It feels like a test of the Constitution itself.
It does have that weight, doesn't it?
And the bench, hearing it, Chief Justice Sanjeev Khanna, Justice Sanjay Kumar, Justice K.V. Viswanathan, they've got a huge task, assessing if this act passes the constitutional smell test, as some are putting it.
And the fact that Chief Justice is on the bench signals how seriously the court is taking this. These are seasoned judges used to tackling complex constitutional questions.
And the number of petitions. It started at 10, but more are expected.
That's the expectation, yes. It shows the breadth of the opposition.
Let's talk about who these petitioners are. It's quite a list. You've got political leaders from all over the map.
It's incredibly diverse. You have Asaduddin Owaisi from AMIM, Amanatullah Khan from AAP,
Manoj Kumar Jha, RJD, Mahua Moitra, TMC, Ziaur Rahman Bark, SP.
Jagan Mohan Reddy from YSRCP, Vijay from Tamalaga Vetri Kazhagam, or Raja from DMK. It cuts across party lines.
Which tells you it's seen as more than just a religious issue, right? It's got major political dimensions.
Definitely. These leaders represent very different groups, but they seem united in their concern about this specific law.
And it's not just politicians. Major religious bodies are involved too.
Yes, Jamia Ulama-e Hind, Samasta Kerala, Jamiatul Ulema, the All India Muslim Personal Law Board, the AIMPLB.
And interestingly, advocates like Hari Shankar Jain and Mani Munjal are also petitioning, but from a different angle.
That's a fascinating development. They're raising concerns about the potential impact on the fundamental rights of non-Muslims.
Really? That's unexpected.
It adds another layer, suggesting the implications might be wider than initially thought, potentially affecting how the state interacts with all religious groups.
And we also have Congress MPs like Imran Pratap and Mohammed Jawad involved. So it's a really wide spectrum of opposition.
It is a very broad coalition.
Okay, let's get into their arguments. Owaisi's using pretty strong language, hostile discrimination. What's his main point?
His argument centers on Article 14, equality before the law. He's saying these specific restrictions in the amendment target Waqf properties in a way that endowments of other religions, say Hindu or Sikh endowments, are just not subjected to.
So, unequal treatment based on religion.
That's the essence of it. He believes it's discriminatory because it singles out Waqfs.
And Amanullah Khan, his challenge is broader.
Yes, he's asking for the whole act to be struck down as unconstitutional, citing multiple articles. It's a more fundamental attack on the legislation's validity.
Then you've got groups like the Association for the Protection of Civil Rights, focusing on minority rights generally, and the religious organizations. Jamiat Ulama-e-Hind called it a dangerous conspiracy. That's powerful wording.
Extremely strong. And Samasta Kerala Jamiatul Ulema called it a blatant intrusion. It shows the depth of feeling, the sense that this is a direct interference in their religious affairs.
Right. And the DMK, they're pointing to the legislative process itself.
Yes, they're arguing that objections they raised during the parliamentary debates, even points flagged by the Joint Parliamentary Committee, were essentially ignored in the final act.
Which raises questions about how the law was actually made.
Precisely. Questions about transparency and whether all concerns were properly considered.
And going back to Jain and Munjal, the angle about non-Muslim rights is still quite intriguing. What exactly is their concern?
It seems to suggest that certain provisions, perhaps around property disputes or oversight, could potentially set precedents or have knock-on effects impacting how the state deals with properties associated with other communities, too. It's a complex point.
Okay. And the AIMPLB, the Personal Law Board.
They're calling the amendments arbitrary, discriminatory, and based on exclusion. Very direct criticism.
Echoed by Mohammed Jawad from Congress, saying it imposes arbitrary restrictions that undermine Muslim autonomy.
Yeah, the theme of undermining autonomy comes up again and again. And the AIMPLB's voice carries particular weight on issues perceived to affect Muslim personal law and community governance.
It's a lot of strong opposition. But the government is defending this act, obviously. They filed a caveat, didn't they, on April 8th?
They did. Filing a caveat is basically the government putting its hand up and saying, hey, Supreme Court, before you issue any orders staying this act or anything like that, you need to hear our side.
Standard legal move, but it shows they're ready to fight for this law.
Absolutely. It signals their clear intention to defend the amendments vigorously.
And what's their core justification? We touched on it, but what's the main pitch?
It boils down to good governance. They say the amendments are needed to clean up Waqf management, which can sometimes be complex or, they argue, prone to issues.
Like corruption or mismanagement.
Exactly. They stress curbing corruption, bringing in transparency, making dispute resolution easier. They frame it all as being in the public service.
But the critics would say, maybe those goals are fine, but is this act the right way to achieve them constitutionally?
That's precisely the counter-argument. Are these specific measures proportionate? Are they constitutional? That's what the court has to decide.
Okay, let's really dig into the specific changes in the act. What are the key things causing this friction?
Right. Let's break down the contentious parts.
First, there's increased government oversight. More government say in how Waqf properties are managed.
Yes, significantly more. This includes giving the government more power in appointing officials to the Waqf boards.
And the concern there is political interference, loss of independence for the boards.
That's the fear, that appointments might be politically motivated, undermining the community's ability to manage its own affairs according to its needs and principles.
Then there's a push for digitization and transparency, putting all the records online, essentially.
Yes, creating digital records of all Waqf properties. On the surface, that sounds good, preventing disputes, better management.
But there are worries.
There are concerns about how it's implemented, who controls the data, and whether it could lead to maybe undue scrutiny or be used in property disputes in a way that disadvantages the Waqf.
Speaking of disputes, the Act sets up new ways to resolve them.
It does. New mechanisms for settling property disputes involving Waqfs.
And the worry is these mechanisms might favor the government.
That's the concern raised by petitioners that the process might not be entirely neutral, potentially weakening the board's ability to defend Waqf properties.
And then there's the really big one, maybe allowing non-Muslims on Waqf boards.
That's definitely one of the most controversial points. Critics see it as diluting the very purpose and identity of Waqf institutions, which are inherently tied to the Muslim community and its traditions.
The argument being, how can someone outside the community fully understand or represent its specific needs in managing these endowments.
Exactly. It touches on the fundamental nature of these boards.
So if you put all these pieces together,
Mm.
increased oversight, digitization concerns, dispute resolution worries, non-Muslim representation, the overall argument is what?
The cumulative effect, according to the petitioners, is that the government gains excessive control. It marginalizes the Muslim community's ability to manage its own religious and charitable institutions autonomously.
A shift in the balance of power, basically.
A significant shift, they argue, and one that potentially undermines constitutional guarantees.
Like Articles 25 and 26, freedom of religion and managing religious affairs. The AIMPLB specifically mentioned those.
Yes, those are absolutely central to the challenge. The petitioners argue these provisions are a direct attack on those fundamental rights.
And Jamiat Ulama Hind sees it as an attack on equal rights guaranteed by the Constitution more broadly.
Right, they frame it as undermining the promise of equality for all citizens, regardless of religion.
Which connects back to Owaisi's point about hostile discrimination under Articles 14 and 15, equality and non-discrimination, because other religious endowments aren't treated this way.
Precisely. That comparison is key to the discrimination claim. Is the law applying equally, or is it singling out one community?
And the DMK adds that procedural layer claiming objections were ignored during the JPC review and passage.
Which adds fuel to the fire, suggesting the legislative process itself might have been flawed or rushed.
So this really is shaping up as a major constitutional clash.
Absolutely. It puts several fundamental rights squarely before the Supreme Court.
Let's just quickly list those key articles again. Article 14.
Equality before the law. The argument. The law isn't equal because it targets WAFs specifically.
Article 15.
No discrimination based on religion. Argument. Singling out WAFs is discrimination based on religion.
Articles 25 and 26.
Freedom to practice religion and manage religious institutions. Argument. Government control interferes with this autonomy.
And they're even bringing in others. Article 21, 29, 30, 300A.
Yes, potentially implicating personal liberty, cultural and educational rights, minority institutions, even property rights. It shows how broad they believe the impact could be.
The stakes feel incredibly high then. What are the potential outcomes here?
Well, the court could strike down the act entirely, or parts of it. It could uphold the act as constitutionally valid. Or it could, perhaps, read down certain provisions, interpreting them in a way that mitigates the concerns.
And if it's upheld?
If it's upheld, it could set a precedent for potentially greater state oversight of religious institutions more broadly, not just Waqfs. That would be a significant shift.
A shift with ripples across India's legal, religious, and political landscape.
Definitely. It could reshape the understanding of the separation between state and religious institutions in India.
It's worth just quickly remembering the timeline here. It all happened fast. Bill introduced, JPC review.
Objections allegedly ignored.
Passed by Parliament, signed April 5th. First petition filed almost immediately April 4th, anticipating the signing perhaps.
AIMPLB and Jamia joined by April 6th. Petitions listed for hearing quickly, April 7th.
YSRCP, CPI joined by the 14th. Government files its caveat on the 8th. Bang, bang, bang.
It really underscores the urgency felt by all sides. The speed shows how contentious this was right out of the gate.
Now, someone listening might still think, okay, interesting legal battle, but it's about Waqfs, about the Muslim community. Why does it really matter to me?
That's a crucial question. And I think the answer is that the principles at stake go far beyond Waqfs.
You mean the balance between government power and religious freedom?
Exactly. That balance affects everyone. If the state can assert this level of control over one community's institutions, what are the implications for others down the line? It tests fundamental constitutional principles.
Principles like equality, non-discrimination.
Personal liberty, the right to manage your own affairs. These are foundational to India's democracy, relevant to every citizen.
And there's a practical aspect too, isn't there? Waqfs often support community services.
Yes, often funding schools, hospitals, community centers, particularly in areas that might be underserved. So disrupting their functioning could have wider social consequences beyond the immediate religious community.
So as we look towards April 16th, this hearing is clearly a pivotal moment.
Absolutely. Pivotal for Waqf management, certainly, but also for India's broader constitutional framework. It's where fundamental rights meet the state's regulatory interests.
You have the petitioners arguing for those rights, for autonomy.
And the government arguing for reform, transparency, better management, a real clash of perspectives.
And we're already seeing this play out in public discourse, right? Lots of debate online and elsewhere.
Oh, definitely. It sparked a lot of discussion, reflecting how deeply felt this issue is.
So maybe the final thought to leave our listeners with is this. In a country like India, so proud of its diversity, its constitutional guarantees, how do we strike that balance?
That balance between necessary oversight and the fundamental right of communities to manage their own affairs.
Yeah, it's a tough question. This case isn't just about the letter of the law, is it? It feels like it's about the very fabric of India's secular democracy. Definitely something to keep a close eye on.